Assalamualaikum and good morning to Ms. Nabilah, our lecturer for Law Regulation in Islamic Banking and Finance, and also to the audience. My name is Nur Atika Firzana binti Rashidi. My metric number is DIL 211002. Our group consists of 4 members, which are Nur Humairah Balkis binti Misrisi, DIL 212030, Zurinah binti Ibrahim, DIL 212023, and lastly, Nur Alia Natasha binti Abdul Hamid, DIL 212026. Legal Framework for Sharia Advisory Council. Central Bank of Malaysia Act 2009. The Establishment of Sharia Advisory Council. Section 51, Clause 1. The bank may establish a Sharia Advisory Council on Islamic finance which shall be authority for ascertainment of Islamic law for the purpose of Islamic financial business. The Sharia Advisory Council may determine its own procedures. Section 57. Effect of Sharia rulings. Any ruling made by the Sharia Advisory Council pursuant to a reference made under this part shall be binding on the Islamic financial institution under Section 55 at the court or arbitrator making a reference under Section 56. Section 58. Sharia Advisory Council ruling prevails where the ruling given by a Sharia body or committee constituted in Malaysia by an Islamic financial institution is different from the ruling given by the Sharia Advisory Council. The ruling of the Sharia Advisory Council shall prevail. However, according to B&M 2005, 2010 and 2019, the goal of Sharia administration is to ensure Sharia consistency and reinforce public trust in the respectability, the board and economic activities of the Islamic Monetary Organization (B&M 2019). Sharia compliance is a crucial component of how Islamic financial institutions (IFIs) operate in Malaysia. Islamic Financial Services Act 2013. Section 51. Transfer order made after appointment of insolvency administrator. This division shall not apply in relation to any transfer order which is sent through a certificate design payment system after the expiry of the day on which the insolvency administrator is appointed in respect of an operator or participant of certificate designated payment system. Section 32. Duties of Sharia Committee and its members. A Sharia Committee and every member of the Sharia Committee shall have such duties and functions set out in any standards as may be specified by the bank under the subparagraph 29. By the bank under subparagraph 29, subsection 2A, Islamic Financial Services Act 2003 and Central Bank of Malaysia Act 2009. Sharia Committee definition. Within Islamic financial institutions, corporate governance is fundamentally shaped by the Sharia, IFIs. According to Chapra and Ahmad 2002, Shahmer, Muhammad and Muhammad 2012, and the OECD 2015, the main goal of corporate management is to foster the talents and interests of various partners that have been drawn out by the investors. This is made possible by a highly organized set of control systems that supports the bank in meeting its objective. However, according to B&M 2005, 2010 and 2019, the goal of Sharia administration is to ensure Sharia consistency and in reinforce public trust in the respectability, the board and economic activities of the Islamic Monetary Organization BNM 2019. Sharia compliance is a crucial component of how Islamic financial institutions IFIs operate in Malaysia. Conclusion: there has been a deliberate and continuous effort to guarantee adequate Sharia governance in light of the amazing success of the global Islamic financial system in just over 4 decades. This will increase public confidence in the Islamic financial system and support the expansions of the sector. The capacity of a Sharia committee to make unbiased judgments regarding the level of compliance of goods and services without being swayed by management is referred to as independence. The Sharia Committee's responsibility in establishing a Sharia compliance environment and risk culture remains crucial regardless of Sharia governance frameworks and structure. A matured Islamic financial system will exist only when practitioners and regulators in the industry can incorporate the Sharia component into the existing corporate governance framework, eliminating the need for a separate Sharia governance framework. This will allow Islamic finance entities to behave like a typical business organization that evolves naturally in terms of resources needs and products offered, such as employing or training talent on the necessary skills, appointing necessary competent individuals to sit on the board, and demonstrating product uniqueness and differentiation in line with business needs. But maturity is not anticipated until the sector has a savvy people, a Sharia-savvy board and management, strong regulations and well-informed customers about Islamic finance.